All right, let's say you hired somebody to train your dog and they did a terrible job. Well, you're going to bring a small claims suit against them to recover the monies that you paid for the training, as well as maybe additional money. And we say the term monies in law, it's not incorrect. The additional monies that you spent to hire a different trainer, and maybe additional mileage and other associated expenses. So you're going to have several types of expenses, but in order to collect all or any of those, you need to substantiate your claims with exhibits and documentation so that you can prove what you are trying to say. In small claims, especially in most civil litigation, it's not what you say as much as what you can prove. So let's say you're really upset because you had a contract with the dog trainer. Well, it was very clear in the contract that this type of behavior was the problem and this type of behavior was going to be corrected by the dog trainer. Now, if you're watching this well before you have any type of problem at all, even if you don't even have a dog, the reason that you should watch this video and other videos like this is that it gets you in the right framework for thinking of what would happen if this relationship, whether it's personal, professional, even intimate relationships, what if this goes sour? What do I have to do to protect myself and minimize the economic fallout if this goes as unfortunately many relationships go and they don't work out? So before you sign up for services, make sure that you have the essential terms in writing. If you're the client, you can basically call the shots if you're working with an individual rather than a large company with their boilerplate agreements. So if you're going to hire a dog trainer to, let's say, correct barking at other dogs while you're walking, that's the essential service that dog training provider is providing you. So make sure you codify that in some type of writing. Now, if there is a breach, you have to prove basically the following in California. So a plaintiff must prove the following elements. 1, the existence of a contract. 2, the plaintiff's performance or excuse for non-performance. 3, the defendant's breach. And 4, resulting damages to the plaintiff. If you need to cite a case for that, you can cite Wall Street Network Limited versus New York Times Company. So you can also use what's called the Casey forms. Now, Casey is an abbreviation, a loose abbreviation, for the California Civil Jury Instructions, CACI. And these are basically guidelines for juries in California civil trials to help them understand the legal standards applicable to the cases they're deliberating. And they're crafted by the Judicial Council to be easily understood by laypersons on a jury. So they're about as simple of a regurgitation of the law as you can properly get. And even though they're designed for juries, they're still useful for plaintiffs in bench trials, which your small claims case is going to be. It's not going to be a jury. It's going to be between you, the defendant, and with the judge as the trier of fact. So you have to basically satisfy all of the essential elements for each type of claim you're alleging. And in addition to that, it helps the judge fully understand what the required elements are. So it does two things. It helps the judge and it helps you help yourself because it's a template of all the required elements that you need to satisfy. You can look those up online, they're for free, and you can also go to the law library, of course. So furthermore, you need to prove that the trainer and you entered into a valid contract. So ideally, you have a written contract that looks like a normal business contract. What happens nowadays, since everything is so informal, you maybe have a few text messages, maybe it's not even a fully licensed, bonded, or even formalistic business. It's just, a guy doing a side gig. It's not an LLC or an S Corp or a C Corp. So everything is kind of relaxed. That doesn't mean you should relax the formal and important business requirements of entering into a contract. So if you have nothing but the guy's verbal assurances that, hey, I'll charge you this, I'll promise you this, I'll have it done by this, then at least send an email if you can, or at the very least a text message just confirming, hey Jim, so just to confirm, regurgitate those key terms, make sure that it's clearly stated what the payment will be and when it will be due and when the performance will be delivered by. What is the latest that you can expect your dog to be properly trained, and what will properly trained be look like? What will that look like? So then when that doesn't happen, and of course I'm a lawyer so I'm naturally pessimistic, when that doesn't happen, then you can show with much clearer, less ambiguous language, because it's written down and mutually agreed in some form, such as an acknowledgement by email or text, that here's what the trainer promised to do, and here is my dog now. So if you can record the before and after, record your dog's problem so it's abundantly clear what the problem is to the trainer and eventually to the judge, and then record the after. And maybe the after is almost no difference, but there is a date stamp. So 6 months later, the dog is still barking at every other dog. And here is the exhibit D to show this is the amount that I paid, whether it's through Venmo or a check. So you have to show your actual damages. You have to show that if you had to spend $1,500 on this trainer, well, in addition to the contract, now you got that out of the way, you've already proven that, here is the payment, here is the proof of payment, here is the amount and the date, and furthermore, here are the additional payments that I had to incur to cover for the breach left by the defendant trainer. The defendant is the trainer in this case. So make sure that you go into court overly organized. You rarely will ever harm yourself by being over prepared. Almost always will you harm yourself doing the opposite. Have everything in a trial binder. It doesn't have to be formal, it just has to have tabbed exhibits, ideally with some kind of basic table of contents, so that you can let your exhibits do the talking. The judge can go immediately to the exhibit that you're referencing, and it's easy for the judge to find the exhibit, and it's easy for the judge to find the language on that exhibit, rather than how a lot of people do it. They just bury the judge in relevant and completely irrelevant documents that have nothing to do with the case at hand. Maybe there are news articles that have nothing to do with your case. There are promises that have nothing to do with it. There are recommendations that your friend gave you for this trainer, still not that relevant. What you want to emphasize and lead with, because the judge has a diminishing focus and a diminishing interest in your case. If you don't lead with your most salient facts first and you bury them in a pile of nonsense, it might be too late to claw them back. Start with your strongest arguments and exhibits first, and then have everything ready to answer any of the judge's follow-up questions. So don't wind your way into the conclusion. Lead with the conclusion, lead with your strongest exhibits that support your conclusion, and then have every other exhibit easily locatable and tabbed for when the judge requests specific follow-up. And when I say you can't over-prepare, you have to anticipate every likely and even unlikely but possible question the judge might ask. And if you can work with one of your devil's advocate friends who's always arguing with you, who doesn't agree with you in politics or anything else, those are the type of people that will pick apart your arguments and better replicate what the either defendant is going to argue or what the judge may ask, because the judge can play a very direct and involved role in small claims court in California. You also want to anticipate the defenses that the defendant is going to make. If you can preempt those in your opening statements, it takes so much of the wind out of the defendant's sails. If you can tell the judge, here's what the defendant is going to say, and here's why it's totally invalid, and here's the exhibit to show why it's invalid. What do you think the defendant's going to do after that? Well, I know you already proved the argument that I'm about to make completely fallacious, but can I make it anyway? Go ahead. You think it's going to be effective? No. And then you also have the chance to do the final statement. If you're the plaintiff, you have to meet your burden by preponderance of the evidence, which is just more likely plausible than not, and you get the first word and the last word. So any loose ends, anything that the defendant brought up that you didn't have a chance to preempt, that's when you can give the final closing statement, which shuts down any remaining arguments the defendant may have made with your absolutely irrefutable, unimpeachable exhibits, and you will have an unfair advantage in small claims court, even if you never have a dog.